And we have to be careful because we don't know what all the other implications are. And so I've always been sort of an incrementalist with respect to this thing. If something's plainly unconstitutional, then we have a responsibility to do something about that. And we have to be courageous enough to do it. But we can't be reckless about it because in the individual case that's in front of us, we would like to see justice done for that particular litigant. But the result is that victims of crime or victims of personal injury or people who have been sued for personal injury claims, now they're going to suffer because we went outside the bounds of the rule of law because we were sympathetic of any particular case. So we have to be disciplined about this. And that's why I say as a judge, professionally, I do this every day. I get decisions, as I say, from the legislature or the Supreme Court I don't like. But if I don't follow them, then lawyers can't tell their clients how to decide a case, how to resolve a case. It's no longer predictable and the law is no longer consistent. And what the people expect from the courts is fair, impartial, consistent decision making.
Justice Sanders?
Well, we often talk about legislative intent. I suppose the people's representative is the legislature, but the people speak for themselves through the state constitution. It was ratified popularly in 1889. I think the Constitution should be understood by the meaning of the words in 1889. I think of myself as a textualist. I believe that the Constitution means what it says and says what it means, which is not to say that there haven't been changes in society since 1889. We have telephones now, we have GPS systems. We had a case where a police officer put a GPS monitor on someone's car. Now, they didn't have that in 1889. Did you need a warrant to do that? We have thermal imaging now. They didn't have that in 1889. Is that a search of property, taking a thermal image? The one case that Charlie and I shared, that he wrote on the Court of Appeals and it went to the state Supreme Court where I wrote an opinion, was Malin versus Pierce County. It involved whether or not a volunteer chaplain for Pierce County violated the provision of the state constitution regarding religious freedom or establishing religion. And I held for the state Supreme Court, I held in favor of the county, and I said that for the most part, constitutional interpretation begins with the words in the text and ends there as well. Recent case we had, this is an 8-to-1 case. I'd be interested in hearing how Charlie or Bryan would have ruled on this case. A woman calls 911. She said her husband just beat her up. He's arrested, put on trial for assault. She doesn't show for the trial. The prosecution plays the 911 tape. He's convicted. He goes up on appeal and he says, hey, this violates my constitutional right in Section 22 of Article 1 to, and I quote, meet the witnesses against me face to face, close quote, or against him face to face. And 8 members of the court said, no, that right wasn't violated. I said, plainly it was violated. Any third grade student would tell you that confronting a 911 tape is not meeting a witness against you face to face, and his rights were violated under the state constitution.
So what I'm hearing is you two believe that it's a living document and you believe that it needs to be based upon its original meaning and interpretation,
yes.
Right?
I mean, there's a provision for amending the Constitution. If somebody doesn't like it, they can.
I don't believe it's a living document. I think you have to try to adhere to the original agreement that the people made at the time of the founding.
Okay.
Some years back, we had Bill Gates Sr. in here, and he was accompanied by Justice Madison, I think. And he was asked, what do you think of the Supreme Court? And he said, they're a mediocre bunch. Madison almost crawled under the table. But, on a scale of 1 to 10, tell us what you think of the quality of the Supreme Court today and what you will be bringing to that court which will correct some of the seeming deficiencies. How about Charlie, you start?
Wow. I've never really tried to rate the Supreme Court on a scale of 1 to 10, and I'm just going to have to kind of give you what comes burst into my mind, Mr. Briggs. I would say overall, first of all, we have some excellent judges on the court. We have some judges that are not quite as excellent. And I guess I would put the court at somewhere around a 6, maybe a 7. That would be my rating. What would I bring to the court? I think there are a couple of things. I think that I've done a lot of of work with groups, trying to forge a consensus on issues, trying to change things, trying to change the status quo, bring about a change, and people always resist change. I think that I've been able to work with people. I think that requires compromise, and I think it requires trying to bring people together instead of insisting on your own position, and feeling satisfied if you can give up part of your position, if the other person can give up part of their position, and you can reach the best blended solution. And I think that that's an approach that needs to, that a collegial court like the Supreme Court, the Court of Appeals, any court where decisions are made by more than one person at a time has to have that. And I think what you see on the Supreme Court now is a lot of divided opinions, and I think that makes it difficult for someone like Judge Chushcoff to apply the law. It makes it difficult, as he says, for lawyers to predict how a case is going to come out, and it foments litigation. And so, I'm not saying anyone should surrender what they think is right in order to achieve consensus, but I do think that these cases, as Justice Sanders says, are difficult cases that reach the Supreme Court. And I think that one has to approach it with a certain amount of humility. I think Benjamin Franklin said that during the Constitutional Convention of 1889, the U.S. Constitutional Convention, when he said it isn't exactly what he would have done, but he's humble enough to realize that perhaps he's not right about everything. And I guess one of my criticisms of Justice Sanders is that he is a great dissenter. If you look at kind of the overall pattern, if you look at the cases that are listed on his website, his own website, 63% of his opinions are dissents. And I think we need someone who can bring people together and create an outcome that can be followed and applied in future litigation. That's one thing. There are others, but I'm going to stop with that.
It does seem that there have been, I'm not going to say there's a huge number of these, but there's certainly been, it seems like, more and more plurality decisions.
How about the rating first? What are you going to
Oh, well, it kind of depends on the case, how well I think about it, I'm going to say. But on an overall basis, I'd probably do more of an 8, I think. I think there's a lot of good work that gets done there. I think there's a lot of good thinking that happens there. I do get concerned about a couple of trends I see. One of the things, and I don't want to bring this completely back to Justice Sanders, but it is one of the things that I think Justice Wiggins Mr. Wiggins talked about was he has been quoted as saying he didn't believe consensus building is worthwhile on the work with respect to the work of the court. If you've served on a jury in Washington State, you know that in order to have confidence in the decision that gets reached, there has to be a consideration of all the evidence and a sharing of views. And you do that by people deliberating together to try to reach some kind of consensus on things. Obviously, we don't want jurors to surrender their honest opinion about whether somebody's guilty or not guilty just for the mere purpose of reaching a verdict. And similarly on the Supreme Court. But I do think that one of the virtues that seems to be in disfavor is trying to build consensus to have a comprehensive and coherent view of what the law is in particular situations. And if everybody's going to go in their own way, it does not give guidance to judges and litigants and their lawyers to try to say what is the law and how do we proceed. This matters a great deal because I've pointed out before.
Are you saying that that's one of your strengths?
I think so. I became presiding judge in Pierce County not because I'm the most popular guy in Pierce County. I don't think I am. And for years, it was sort of an inside joke at the courts. I can't believe I'm saying this, but I think I agree with Bryan. But I became presiding judge as time went by for a number of reasons. One, as time went by, people began to realize, he's right about this and this and this. We've got to listen to this guy. And secondly, when I was in the minority, when I didn't get my view, I didn't just sort of sulk, not continue to try to work with my colleagues. I tried to make the system go the way they thought they wanted it to go. And so I think as time went by, I built trust with my colleagues that this is a person who can be a leader in our court, whose judgment is good, who can work and cooperate with us even if we want to go a different way than he wants to go. He's not a person pulling in the opposite direction. He's the one who's pulling to try to get this thing done right on behalf of the court. It's not my ego that matters.